Hello there, my name is Jonathan Page. I am a business attorney that helps small to mid-sized businesses get their business in prime legal condition. Now, in my experience, almost every single business has legal exposure in at least 5 core areas. Today, we're going to discuss the legal exposure in the area of commercial transactions. And in particular, we're going to focus on service contracts. Now, oftentimes, some business owners, especially when they're first getting into business, will go grab a contract from somebody else in the industry or download a form off the internet and then try to kind of massage it and maneuver it into the contract that they're going to use with their customers. In general, we have found that this is likely a mistake. When we get these contracts before us or we're doing any sort of litigation around service contracts, we often find all sorts of problems with those contracts. So what I want to do is kind of run down some really important provisions that when you have a service contract or you're having one drafted that you need to pay particular attention to. The first thing that is really, really important in a service contract is scope of work. You need to be very, very clear on what it is you as a service provider are doing and what you're not doing. So if you provide IT services and you're providing managed IT services and they're paying a monthly retainer for those managed IT services, does that include unlimited help desk support? Does that include unlimited calls to your office? Does that include unlimited visits to the place of work? There may be limits and restrictions on what's included and what's not included, and really drafting up that scope of work very, very carefully and making sure that you're not getting stuck doing things that you didn't plan for in terms of how you priced it. So the scope of work is very critical. Now, most business owners get that. If anything makes it into the contract, especially once they download, it typically is the scope of work. That's the one thing that they make sure that they get into their contracts. The other things that they don't think about that I see often in these service contracts is the second thing I want to talk about, change orders. Now, let's talk about that IT guy. He is doing a big project, and the owner walks in the middle of that project and says, hey, can you add an extra workstation? You know, this is typically how things happen when you've got a good relationship with the owner and you're like, yeah, I can do that, but it's going to be an additional fee. You might say that verbally, but the business owner doesn't quite hear the IT guy or misinterpreted what was said. And then later on, when they get the invoice, they say, whoa, I didn't realize that this extra workstation was going to be, 25% more added on the bill. And now you get into a dispute. And unfortunately, the contract says, I'm only paying you for this. And it didn't mention an additional workstation. So oftentimes you can include a change order provision. And we can draft these in ways that are really, really favorable to the service provider, and they can be drafted in ways that are favorable to the person who is engaging the service provider. But there can be a mechanism there for, okay, when you ask me for something that's out of the scope, that's not in this scope of work, how do we price that? What do we do? For example, one easy way to do it is an hourly rate. You know what? This scope of work included this flat fee, but anything that's going to be out of scope, you're going to go ahead and agree when you sign this service contract that you're going to pay me $95 an hour. So to the extent I start billing or I start doing work that's outside of the scope, I'm getting $95 an hour. That makes it clear, it's easy to calculate, and then it's not a surprise when it gets on the bill. And it also protects you against the business owner coming back later and saying, hey, I didn't know that it was going to be that much money. The other thing that often is neglected or overlooked are termination provisions. So, oftentimes there's not even a termination provision, which begs the question, when does the contract terminate? And sometimes there is a termination provision, but there's nothing discussing about renewal, whether it automatically renews, are there any procedures for doing this? Sometimes you'll hear 30 days advance notice, so if you have a retainer agreement and that agreement goes into perpetuity, meaning it's just going to continue to be in place and the owner's going to have to pay every month, then you're going to want to have a way to be able to terminate that. Do they need to give you 30 days advance notice, 60 days advance notice? Does it have to be in writing? These are all sorts of things that need to be thought through and discussed, and it needs to make sure that it gets into your contract. Which brings me to the fourth provision that I often don't see in contracts. cancellation. So just give the example of the IT guy. Maybe it's a 12-month contract and it's a retainer. So the business owner is paying that IT guy every month a certain amount. Now that IT guy, the brunt of the work may be in month one, meaning they're spending, 40, 50 hours in that month, but then the subsequent months it's down to 5 or 6 hours a month. But the fee's the same every month. So there's going to be a big problem if the business owner cancels or terminates the contract in 1 month, in month one, because the IT guy might lose money. So you can have a cancellation provision. And one thing to note is there is a provision within our law, especially Georgia law. Let me grab that phone. Not as important as what we're doing today. So I'm going to put that down. But just to note, sometimes in Georgia law, or what Georgia law states is that you can't have a contract penalty. You cannot penalize somebody. So you can't say, if you cancel this contract, you owe me $1 million. It has to be based on something reasonable. So you can have in your contract a cancellation fee, and what we would do if we were drafting your contract is we would make sure that that cancellation fee was based on something. Like, we typically spend 100 hours, so the cancellation fee is based on 100 hours of work, extra work that we do in month one if you were to cancel in month one. So those are some things that you would want to make sure you pay particularly close to with the cancellation provision. And then a few other ones that I'll go through real quickly. Number 5 is your intellectual property, your IP. So you're providing a service. They're taking that service in exchange for money that they're paying you. You may be designing a website. Well, who owns that website? Do you continue to own it and you're giving them a perpetual license, or does the business owner own it? One of the key things that's really kind of a really good tip here is if you're going to give the business owner ownership over the IP, say the website, which is typically what the situation is, you want to be able to hold that IP ownership hostage if they don't pay you. So things that you can incorporate in your contract is that IP rights, the ownership to the website actually doesn't transfer until final payment, until full payment of the entire job. So they don't pay you that last payment, you can send them a letter and say, well, I'm sorry, I actually own that website, and until you give me that last payment, you don't own it. So there's little provisions that you can put in there to really protect you in that situation, even when you're assigning ownership over your work product to the business owner. The other thing that you want to pay particular close attention to that's often overlooked is a form selection clause. If you do business with companies that are out of your state, so they're in Tennessee or Alabama or in Florida, and you regularly do business with those sorts of companies, you're not going to want to have to go sue them if they don't pay you over in Tennessee or Alabama or Florida or some state that you don't normally operate in. It's going to be really, really expensive for you. And that's going to make it be a hindrance in you in trying to go and collect that owed money. So a form selections clause, what it does is a form means that's the place you can go sue somebody. It makes it wherever you want it. So if you're in Georgia, then you can write in there that if they have to go sue you, or if you go sue them, they're going to have to do so in Cobb County Superior Court, for example. So you can specify in there where suits have to take place, which makes it very convenient for you if you have to go after that money. You're just going, a few miles away from your office in order to file a lawsuit, and it makes it very inconvenient for them, which improves your chances of collecting or at least getting a judgment. And the last two things I want to discuss is number 7 is a limitation of liability. I had a client recently tell me, well, we just want to do contracts for our really big jobs. For those smaller jobs, I don't even want to do a contract. And what I explained to him is it's not necessarily the amount of the job. What you want to protect yourself against is liability. What if you screw up? So say, again, you're that IT guy, and all they hired you to do is go install one computer. And then 3 days later, that computer crashes, and all of their data is lost. Well, that owner is going to come back to the IT guy and not just ask for the amount that was paid. They're going to say, you know what, I lost a $50,000 worth of business that day because my data was lost, and you installed the data. So not only do you owe me the price of the contract, but you owe me that $50,000 as well. Well, what a limitation of the liability clause does is it limits your liability. It specifically says in there, and what the business agrees to, is that to the extent you are negligent or you do something wrong, then the most that they can recover from you is the price of the contract. They cannot recover special damages or consequential damages, things like lost profits and those sort of things. So that clause is really, really key and really should make it into your service contract. And finally, the last thing that I want to discuss about service contracts is the attorney's fees provision. So your customer doesn't pay and you've got to go collect, you're going to get an attorney, and that attorney is going to cost you money. So now the money you spend with the attorney plus the amount you recover is going to give you a net loss. So if you're trying to recover $20,000 and say you're able to recover 10, so you've got that $10,000, but then you had to pay 5 to the attorney, you really only have $5,000 that you recovered. So it makes it a huge hindrance in going after people. Georgia law has an attorney's fees provision. If you put in your contract that you can recover your attorney's fees, your reasonable attorney's fees and collection costs, should you go after them for non-payment, and they agree to that, then you can go after them for non-payment and get your attorney's fees, but it's got to be in your contract. There are also other attorney's fees provisions like bad faith, but those are very, very difficult to prove. There's a really high standard, so the best practice is to make sure you get that attorney's fees provision in your service contract. So these are only a few of the provisions, some really, really important provisions, and they're ones that are often overlooked, provisions that we don't see in service contracts when they get in front of our desks, especially ones that were downloaded from the internet or were taken from someone else in the industry. These are the things that you want to look for. Make sure that your service contract has these sorts of provisions in there and provide you that sort of protection. If you need to contact me, you can contact me on our website, which is ihlawyers.com, and you can also get access to other videos like this one. Thank you.